Good morning, everyone, officially. For those that don't know me, my name is Sarah Hagee. I'm the Executive Director here with the Electrical Association of Philadelphia. And this morning I am joined by my colleague, Matt Dybert, our Program Manager, as well as our presenter Nella Bloom. Oh my goodness, I completely just baffled that. Good morning, Nella. Thanks for joining us.
Good morning, Sarah. Thanks for having me.
Absolutely.
So,
Before we Hold on, I'm sorry. Thank you, Matt. Before we get started, as I've said in the chat, and if you didn't have a chance to see it, we are recording today's session. So your cameras are going to be turned off as well as your mics. That doesn't mean, however, that you cannot ask questions. We definitely want you to send those questions in using the chat feature. Any questions that you don't want the whole group to see, you can send over to Matt Dybert directly, and he'll go ahead and prompt that question towards the end of the session to Nella. It is now my pleasure to formally introduce Nella Bloom as outside general counsel. Nella helps small and new businesses throughout their business life cycle from startup to shutdown. Nella specializes in helping clients buy and sell businesses, representing a mix of industries and sectors. As a business owner herself, Ms. Bloom understands the mindset of an entrepreneur and the personal aspect of being a business owner. Nella is licensed to practice in Pennsylvania, New Jersey, and Delaware, and is a frequent presenter on issues relating to small and emerging business and corporate bankruptcy. She was a Pennsylvania Rising Star in 2018 and 19, according to Super Lawyers magazine. So with that, Nella, I'm going to turn it over to you. Thank you.
thank you. What a lovely introduction. I'm so pleased to be here this morning. Thank you so much for having me. And I'm going to be speaking a little bit about a graceful exit and selling your business and succession planning. Matt, can you advance, please? So, first, a disclaimer, this is not legal advice. I am not your lawyer. If I am your lawyer, you will know because we will sign an engagement letter and we will agree on work to do. But if you have specific questions that relate just to your situation, you may want to consult your own attorney or advisor. We will be having sort of a more general conversation today about structuring your business for a sale and looking forward to the next steps of your business. All right, Matt, could you advance? So what are we going to be talking about? Before you start thinking about selling, what do you need to do? What is the sale process, just sort of generally? We're going to be talking at a very high level here. Succession planning, and then dissolution and winding up. Next, please. So before you start, next, your corporate books and records must hold up to scrutiny. I really mean it. That's why it's in bold and underlined. Next, please, because this is what I mean by hold up to scrutiny. Let's say that you have a business and you say, well, I really want to get my hair cut, and I think that's a business expense. And I think it should go through the business. I think the business should pay for my haircuts. You know what? If no one's looking, and you can say that with a straight face, then maybe you can do that. Maybe you can get your hair cut on the company dime instead of doing what you would normally do, which is, of course, waiting for either a distribution or a paycheck, taking that money and then going and paying your barber. But if you are getting your business ready for sale, perhaps a barber expense is not a business expense. Get those financials in order. Stop paying any personal expenses out of the business. Make sure that the taxes for the business are fully paid and documented. I've had several sales that I've worked on fall through because of a lack of transparency and completeness in paying and reporting income. Here's what I mean. So a couple of years ago, I had a buyer, and they wanted to buy a small restaurant. And the sellers had told them, here's how much I earn every year. This is what my gross is. But I will tell you that my taxes don't reflect it. And so my client, the buyer, told me that. I said, wait, what? They said, yeah, it's usually a cash business. I said, if it's a cash business, whatever it is they're telling you and whatever it is you're paying, you would be paying taxes on, two different things. Not only can they not substantiate the income, but you, as the buyer, could potentially have a huge tax liability when the city of Philadelphia realizes that the seller has not been paying its taxes, and they look around to whoever's left. Who's now in this restaurant? Who's operating the restaurant? Oh, buyer, maybe it's your problem now. There are some steps to take to avoid that, but we all have met taxing authorities. We kind of know the deal, and they will do what they want to do. It's hard to fight them, right? The next thing is make sure that your corporate organization and your books are complete. Um, your and by this I mean if you are an LLC, you should have an operating agreement. If you have a corporation, you should have shareholders agreement and bylaws. If you are a sole proprietor, it is really hard to sell that because all that stuff is just yours. So paying attention to that corporate organization before you sell is really important because you have to figure out what it is the company has and whether and how that transaction would occur, right? If you're sole proprietorship, it means you own the truck. So how are you that you could just sell a truck, but you're not selling a business, you're selling a truck. And a truck may not be a whole business. If you built something that independently has value, but as a sole proprietorship, it's going to be harder to sell, right? Also, your organizational documents might reference individuals who aren't even involved in the business anymore, partners who have been bought out, shareholders who have been bought out, people who, God forbid, have died. So going back and taking a look, seeing if you need to amend any of those documents is going to be really key. And in terms of how far back you have to look, typically a buyer doing due diligence on a company will look back 2 or 3 years. So if today you want to sell your business, look back over 2 or 3 or 5, even 5 years to make sure that those things are complete, that your financials are in order, the taxes are all fully paid, they've all been documented, your books, your corporate documents and books show what's happening at the business right now. All right, Matt, can you advance? So step 2, sale. The real thing to think about here, there are 2 main ways of selling a business. You can either sell the equity or you can sell the assets. I like to think of this as kind of like an estate sale versus selling a house. So let's say Great Aunt Mindy dies and you have to take care of her estate. She's got a house, she's got the stuff in the house. So the asset sale is like an estate sale. People go in, they say, oh, I want to buy those bowls. I want to buy, that dresser. I want to buy those old clothes. And the sale of equity is like selling the house itself. If you are buying some bowls, you do not necessarily expect that the tax lien on Aunt Mindy's house is going to be sold along with clothes, right? It's just stuff. But the opposite is true when you are selling equity. If the equity, meaning the ownership of the house itself, the business itself, is being sold, then it is reasonable to think that liability issues relating to that structure will continue on with whoever has bought that house, that property. But if you are talking about a sale of assets, it is far less likely that the liability would continue, right? And when I talk about a sale of assets, we're talking about intellectual property, trade dress and goodwill, like the name of the company, its internet presence. We're also talking about the hard assets, equipment, supplies, inventory, leased assets, which are a little bit different, right? If you have a leased asset, you have to go to the leasing company and say, hey, I want to transfer this lease. Let's make sure it can happen. It's not necessarily free to, you're not freely able to assign that to someone else. But those are the kinds of assets that would be sold at an asset sale. Matt, can you advance? All right. So let's talk briefly about sale timeline and documentation. I could talk about this for like 7 hours, but that's because I do this stuff a ton and I think it's really interesting. I know not everyone shares that opinion with me. You will see I have several opinions. that I think people do not share, but no one asked me, but I'll tell you anyway. The sale timeline and documentation. So the first step is a non-disclosure agreement. A non-disclosure agreement, as some of you probably know, is a promise that if I share this information with you, you're not going to take it and do anything with it. You're not going to share it. You're not going to use it. You're just going to have it for the purposes of, in this case, assessing whether you want to buy the business. Um, so the first thing is you sign an NDA, and then start negotiations, which may or may not give rise to a letter of intent. A letter of intent has the bare outline of what's going on here. What's being sold, what's not being sold, what's the price, how will it be paid? Are there any really important things we want to address right away, like a non-compete or an exclusivity agreement or consulting, um, which we'll talk about in a minute. Uh, and the last thing it'll say is this is not binding. And that's why I'm not sure that a letter of intent is always like the best way of going about doing things, because it's not binding. Why are you spending time on something that's not binding? It is useful to say, here are the things that are really important to the parties in the sale, but you can do that without going through the rigmarole of getting a letter of intent together. So, and also, all of this is negotiation anyway. You can negotiate points in the contract up until the time it's signed. So, anyway, that's my feeling on letters of intent. But oftentimes, then you have a deposit that's exchanged it can be refundable or not, depending what the parties agree. Um, and it's really the way I think of a deposit in this situation is it kind of holds in place the deal. So even though there's not a deal yet, the parties say, okay, for this period of time, we're going to understand that we're moving forward exclusively. And I, the buyer, am paying you, the seller, so that I can maintain that exclusivity for a certain period of time. And if it doesn't work out, it doesn't work out. But that's sort of the time value of the effort we're putting in right now. Next is due diligence, which is that is the house inspection, right? We have moved away from the analogy of the house as the as the LLC corporation or the structure itself, and we're moving on to the house as just an asset to be sold. But the due diligence is going to be very, I mean, look, you're buying a business or someone's buying a business anyway. They should be able to see as much as they want so that they can make a full and fair assessment about what it is they're buying and whether they want to buy it. This due diligence includes, if there are vehicles, let's look at them. Let's make sure the title is clean. If there's leased equipment, let's make sure that it's not subject to, that there's no risk that it would be taken back. Let's make sure the payment history is correct. If there are employees that have that might have claims, let's see if we can clear those up beforehand. Let's see what those claims are, at least, if there are any kind of potential liabilities that employees might bring. At a minimum, what I like to have in due diligence from a legal point of view, this is not from like an inspection of books and records point of view. And let me wind back. I do not know much about taxes, and financial due diligence is not it's not my business to tell people what sort of finances look good or don't look good. Like, I'm a lawyer, I can't advise on that stuff, but I can advise on what potential legal liabilities might be. So from my perspective, in terms of due diligence, what I like to see is a judgment, lien, and UCC search. I want to make sure that whatever is being sold free and clear of any kinds of liens, claims, encumbrances, mortgages, what have you. I want to make sure that if assets are being transferred, nobody's going to come out of the woodwork and say, you can't transfer that, I have a lien on it. You know what? We were going to talk about liens and UCCs in a minute. Let's talk about them now. How about that? If you are familiar, like, if you've ever bought a house, but you've had a mortgage, in all likelihood, unless you are one of the blessed few who just buys a house with cash. I am not one of those. Um, the mortgage is so there's a when you sign a mortgage, there's a promissory note that says I promise to pay. The mortgage says dot dot dot, and if I don't, you, the bank or lender, can foreclose on my mortgage and take back my house. And that's recorded in the deed book in whatever county you're in. So if I want to see if there is a lien on my home, I go to the recorder of deeds or have someone else do it who knows where to find it. I got a guy. If you ever need a guy, I got a guy. But he'll go in the deed book and he'll say, "Oh, okay, this house is subject to a mortgage from M&T Bank dated X, and here's the number, and here's how, and we can contact the bank for a payoff letter." So the mortgage is notice to the whole world that there is an obligation on the property. The same can be true with a commercial loan agreement. So if you are buying a business and you have a lender, or if the seller is financing, um, the lender will have a promissory note and security agreement. The promissory note's just like the promissory note for a mortgage. The security agreement is like the mortgage. So the promissory note says, I promise to pay, dot, dot, dot. And the security agreement says, and if I don't, you can take back my stuff. And here's the stuff you can take back. And they list it. And when you have a sale, the stuff is the stuff that's being transferred subject to the sale. So it might say inventory and date, equipment, liquor license, blah, 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 whatever's being transferred. Then whoever has that, whoever holds that note, whoever has the promise of payment, can file of record what's called a UCC, which is a Uniform Commercial Code statement. And just as with a mortgage, you can look in the UCC records and see what assets are subject to a lien. So that's what that means. The reason you would look at this in due diligence is to make sure that there are no superior liens on these assets. So what I do with my sales is I get my guy to run a judgment lien and UCC search. And that way I can see if there are prior liens on the assets that might, and so if my client is going to take these assets subject to a lien, meaning that if payment stops, whoever lends can take back the stuff. This is not a good outcome. That's why I want to know. So that at least we know what kind of risk there is for my client in terms of that due diligence process. Okay, so that was due diligence. Asset purchase agreement and other items. So during the due diligence process, the lawyers get busy drafting an asset purchase agreement. And I've seen these as short as 3 pages and as long as 75. And sometimes you need a long one, depending on things like, what was the one that was really long? That was all about payouts. The asset purchase agreement will detail the method of payment. If there are payouts, that will be in the asset purchase agreement. Sometimes things like restrictive covenants are inside the asset purchase agreement. We'll talk about those separately. The asset purchase agreement will attach a list of exactly what's being sold. As long as the parties know what is subject to sale and what is not, that's fine. As long as you can say, if there's a room with a lock and a key, and you say everything in that room and only I have the key, then that's everything in the room. That's what's being sold. If people are doing that, I typically like them to take pictures, so at least you know kind of what's being transferred. That's a little informal. I like something a little more formal, like 3 Dell computers from 2016, which at this point is pretty long. Or 5 office chairs, 3 LCD screens, stuff like that. Along with the asset purchase agreement, there are some other ancillary documents. There's what's called a bill of sale. There's sometimes people do a closing sheet, which looks a lot like a property closing sheet, which used to be called the HUD. Um, there may be some documents relating to funding if the buyer doesn't have cash on hand to pay in full. So this could go through a bank. And it could be just a promise to pay over time. If it's a promise to pay over time, then the seller should have that promissory note security agreement that we talked about just a moment. And we'll talk about guarantees in a moment as well. At the time, so once we know we're going forward with the closing, I like to have a bulk sale or tax clearance application filed. These are applications that are submitted to the Department of Taxation in whatever state the seller business is in. And the purpose is to say, hey, Department of State, Taxation Department, we're going out of business. If you think that we owe you anything, tell us now and we'll pay you. The purpose is to avoid those continuing tax liabilities from the seller that might trickle down into the buyer's liability. Now, in an asset purchase agreement, you often say, in fact, I don't think I've ever seen one that didn't say, if we, the seller, had any obligations that arose before the sale, we will cover them. Now, those are great to have, but then the problem comes when you have to enforce them because that takes money. So if there is a liability and the buyer says, hey, seller, you told me that I didn't have to pay that because that's your liability. The seller might say, oh, not my problem, in which case the buyer now has to sue the seller for indemnification. But making sure that these obligations are documented beforehand and are understood beforehand goes a long way to them being paid before the closing. Bulk sale filings in Pennsylvania, unfortunately, take a really long time to go through. The longest I've heard of is 2 years, which is ridiculous. New Jersey system is much easier. You're supposed to file it within 10 business days before the closing, or I'm sorry, at least 10 business days before the closing. And then the taxation department actually sends you something back saying, here's what you should withhold from the sale, because that's how much tax we think is owing. And then the parties withhold that in a tax escrow in order to allow the sale to go through. And the purpose of a tax escrow is that the seller doesn't get that money. It's money that the seller would have had to pay in taxes had they been doing things the right way. So it's held aside, and then the taxing department does a final review and they say, okay, you can release this money back to the seller. You don't owe anything. Or we think you owe this much, pay to us. But that way, at least, you know that there is money to cover that obligation, that the seller has not taken the money and run, basically. All right. There may also be restrictive covenants, which we will talk about in a little more detail in a moment. Then after you have your bulk sale application submitted and hopefully back, though maybe not, you close. And the closing is where money changes hands. I will say also that the timeline here is not, this timeline is a sample timeline. Sometimes people sign the APA, the asset purchase agreement, before the closing and then move forward to closing. That's fine too. It all depends kind of what the parties want to do. And then after closing, there are potentially other continuing liabilities or obligations. Excuse me, if the UCC judgment and lien search has shown that there are liens, then those get paid off with the proceeds of the closing. And then the seller gets what's left. It's kind of like, think about this, kind of like selling a house, right? If you have a mortgage on the house, you pay it off with the sale of the house, and then whatever's left over, you keep, right? All right, Matt, can you advance? Thank you. Oh, and I should say, I'm not sure if people are coming in a little bit late. if there are questions, we can address them at the end, though we did get some advanced questions. So we will be, to the extent that I can, I'll be talking about that or weaving those in. All right, so we talked a little bit about the promissory note and security agreement. We had a question that came in beforehand, which was, do you have to be part of uh, an investment group, or what do you think of in terms of funding? And the answer is, with my buyers and my sellers, I tend to like bank financing best. And the reason I like bank financing best is because the bank is in the best position to chase down the loan. The seller is not. The seller is just someone who has built a business and wants to sell it, and someone says, hey, I'll pay you over time, which sounds really nice, except when they stop paying. And then the seller is like, well, what do I do now? Like, I have to enforce this? Oh, I have to enforce this. And that takes time, it takes money. And a bank has a department to do that. They can do that. So if the bank lends the buyer the money to purchase the business, then the seller gets a payout on the day of closing, basically. Like that's their payout. And now it's up to the buyer to pay the bank back over time. I like that much better. I think that's a lot cleaner. The seller doesn't have as much ongoing skin in the game. They can move on with their life. So when we're talking about, so we talked about the promissory note and security agreement. Let's talk about personal guarantees. Personal guarantees are, I see the point for personal guarantees. It's the individual behind the business saying, if my business does not pay on time and in full, you can come after me because I have faith in this business and I also have a personal stake in the success of this business. I can do this. I will guarantee this. Personal guarantees for non-owners, I've not seen that. I know that they might exist, but I don't think that they are appropriate. Now, I will say that there is an exception. If there are personal guarantees, if you are in, well, if you're in Pennsylvania, or rather whoever's whoever's obligation it is to pay is in Pennsylvania and they are married, their spouse, I think, could be reasonably expected to also personally guarantee. Why? This is one of those. So this slide is all about the weirdness of Pennsylvania law, which is for me fun because I don't know why, because I'm a very strange person. Personal guarantees are enforced. So wind it back. If you have if one spouse has an obligation to pay a debt, and the other spouse does not have that same obligation to pay the debt. In Pennsylvania, that obligation does not attach to marital property. So if, let's say that my husband, so I own this house together with my husband. Let's say that I have a claim against me because I went into a parking lot and hit someone over the head because, I don't know, I was in a mood. I did it. And there's a judgment against me personally. That judgment cannot attach to my house because it's only my obligation. It's not my husband's problem. He didn't hit anyone over the head. So in the same vein, a personal guarantee in Pennsylvania against just one spouse does not attach to marital property. So if there's an obligation to pay, that spouse, the existence of that spouse kind of invalidates the ability of that judgment creditor to have a lien on the house. But under normal circumstances, personal guarantees, I don't love them, but I understand that they may be necessary. And if I'm on the seller's side, I want that personal guarantee and I want it from their spouse as well. Now we talk about confession of judgment clauses. This may be something that people are familiar with, hopefully not, but another weird section of Pennsylvania law. A confession of judgment clause is a clause in a commercial contract where there's a promise to pay over time. So we're talking about a mortgage or a note or a lease. And what it says is, if I don't pay this obligation, then you, holder, beneficiary of the obligation, whoever gets the payment, can take this agreement to court, enter it as a judgment without even the judge looking at it. It's just the clerk says, oh, yep, there it is, stamps it, files it. And it's up to you, the debtor, to go to court and get that lifted or stricken. It's a really, really extreme remedy. Um, Most contracts in Pennsylvania have them. I personally think they are unconstitutional, and I also personally have used them because they are a tool for my client. If my client is a seller, I want a confession of judgment clause in that note. I want it in the security agreement. I want them to be able to confess judgment if there is a promise to pay that is not met. And I will also say, if there is a guarantee of a commercial obligation to pay over time, that confession of judgment clause can also be in that personal guarantee. Now, it's enforceable to the extent that it's enforceable anyway. So I want to if I want to confess judgment on a personal guarantee, but all of that person's assets are held, as marital property and their spouse didn't sign a guarantee, then like I'm still out of luck. But that's what I'd like to see. And but again, I don't love those clauses. Anyway, Matt, can you advance, please? All right, let's talk a little bit about restrictive covenants. Let's talk about non-solicitation first because it's easier. Non-solicitation is when someone sells. So typically, when you sell your business, you're promising to uphold a couple promises. You're saying, all right, I agree that as part of the payment for this business, and part of what I'm giving you is I'm giving you sort of a wide, free road to do it, to run this business in the way that you see fit, right? This is your business now. I agree that I will not try to get my former employees, my former contractors, my former vendors, suppliers, clients, customers to move away from the business. That's a non-solicitation. I agree that I will not solicit them to go do something somewhere else. It doesn't matter if well, depending on the language, it may not even matter if I am even involved in the business that they're going to. If I just want to entice them away, that's enough for a non-solicitation. Um, a lot of agreements also have a non-compete provision, or a non-compete is part of the sale. And the non-compete, as I'm sure most people know, is I promise that for a set period of time within a geographic area, I will not compete with the business that I've just sold. I'm not going to start a new business. I'm not going to be involved in a business. I'm not going to be an owner of a business. I'm not going to, be an employee or contractor, consultant, whatever, in that kind of business. Non-competes have to be reasonable in terms of time and geography. And what's reasonable depends on the circumstances. So let's say I'm a barber and I have a non-compete and I sell my barber business and my non-compete is, 500 miles in 5 years. That's not reasonable. I live in South Philly. I can't walk 3 blocks without hitting 2 barbers, they're just everywhere. Most people have hair. It's got to get cut. So it's not reasonable for me to think that that people would be put off, like the geographic scope of how far I think someone's going to walk for a barber or go for a barber isn't 500 miles. It's much, much smaller. And 5 years is a long time. However, I just had a matter where someone had a business that was manufacturing ice cream, and the people in the buyers, that is, wanted a non-compete that covered the entire US. And I was like, well, that doesn't seem reasonable. And they said, well, actually, it is, because this is a unique product and we want to expand throughout the US. So we would like 2 years and throughout the US. And I was like, wow, okay. I don't love that. I don't think people are going to drive to California for ice cream, but I understand the point. I understand what you're doing here, and I understand that the buyer wants to expand out geographically so that the product is everywhere. It is in California, and you wouldn't want to have a competition there. But I will say also that non-competes are becoming less and less enforceable, and that the circumstance in which they have consistently been enforceable are when you sell a business. They are enforceable against the prior owner of the business. But if you have specific questions about non-competes in the context of like employment agreements, maybe we can address those offline, because there was recently some changes in the law about those, and whether non-competes for just your typical employee are enforceable or not. Okay, Matt, can you advance? Thanks. All right, part 3, succession planning. There's only one slide on this section, and there's a reason for it. And the reason is identifying a successor isn't a legal issue necessarily. It's a business issue, but it's also an emotional issue. Let's address the easiest one first, which is third parties. So if you have a third party successor, it means you've identified someone who you think is going to be the who's gonna continue on your legacy. Or it means you no longer care. You're done. Whatever happens with the assets, with the business, not your problem anymore. The vast majority of my work is with this kind of situation. The seller says, I just want to sell my business. I'm done. I'm tired. I want to retire. I want to go spend time in Florida. They don't necessarily care about their business anymore in the same way that they did. They just want out. They find a potential purchaser. There is a formal process. They enter into an asset purchase agreement. They do all the stuff that we already talked about, all that stuff we already talked about. And then they sell and they're like, okay, all done. The end. That tends to be very clean, very clear cut. Then there's working with employees. I've done a couple of these too, where employees will purchase out will buy out the assets or the owner. And there are a couple different ways of doing this as well. It's somewhere between arm's length and not arm's length. Arm's length is like, I've never met this person before. Like this is what a willing buyer and a willing seller will pay for this business as is. But employees, oftentimes when you see an employee or employees take over a business, it means that employee is very involved in the inner workings of the business. It's not just some guy who, comes in 3 days a week. It's someone who's very intimately involved and who knows the ins and outs, possibly better than the owner, who might be doing other things as well. And the employees tend also to do a more arm's length transaction. There may be more of an overlap in terms of consulting. Maybe the owner will stay on for a bit and do some consulting with that employee, or on an as-needed basis. But the employee really is, the due diligence process is a little more streamlined, because typically they know at least some of what's going on, maybe not the financial information, but they get a sense of what's going on with the business. They're familiar with it. They're familiar with how the equipment works, with what is in date and not in the storehouse. They tend to be fairly successful. One of the companies with which I've worked to do this, where an employee bought the business, it's going gangbusters. It's just, I'm so impressed with the progress that they've made, that the buyer has made over 4 years. It's amazing. Now, family. I heave a gusty sigh. And look, I'm a member of a family-owned business. It's a little different. I brought my father into my business. He is the other Bloom in Bloom and Bloom. I think with family, it is, and so I would say we had a question in advance. There was someone who wrote and said that he wants to retire and is thinking of passing the business on to a child and kind of wanted to talk about that. I think the conversations and openness in a family transaction are so important right at the beginning, because I think there could be a fundamental disagreement about how the transaction happens. A child who is a successor might think that this is a gift. The parent who is the seller might think, this is my major asset and I want to get value out of this. Because look, we put our blood, sweat, and tears into these businesses. If you build a business, even if it's not from scratch, it doesn't matter. If you build a business and there is value in that business and it is part of your retirement, there's no reason you shouldn't expect to get something out of that business when you retire. This also is a question, sort of how to structure this with family is also a question to address with an accountant, because an accountant is going to be much more likely to be able to tell you, okay, if this is a partial gift, here are the repercussions. If this is a sale over time, here are the repercussions. If it's a transfer outright, a transfer outright, here are the repercussions. And thinking about that, if especially in a family context, there may be much more of an expectation that a child or family member could pay over time because, hey, it's me, like, you know me. So thinking about how to structure those payments over time is really important, not just because you don't want to foreclose, on a loan that you make to your child because they haven't. Because with all of this, like, a payment over time is essentially a loan. You're loaning them the money to so that they can buy your business and they pay it back to you, right? You don't want to foreclose on that and make Thanksgiving horrible. Sometimes it's hard enough to have a meal with your family without having a big fight. But I think that the issues related to family transfers can be mitigated with a lot of open and honest conversations. Tell me what it is you can do. Tell me what it is you want. Here's what I want. Here's what I think the business is worth. Here's how I would want to get my value back from the business. Because if you are not on the same page, you should probably figure it out right now. And if you really want to do the transfer anyway, figure out what your bottom line is. Like, will you take nothing to have the business continue on? It's an interesting conundrum, right? But again, having the conversations early and the key to all of this is information. The key to any kind of transaction like this is information. What liabilities exist? What am I willing to do? What am I willing to take for this business? Is it worthwhile for me to work with my nephew, or do I just want to say, look, I'm sorry, I don't have any other retirement. This is my retirement. I have to go. I have to sell this. All right, Matt, next slide, please. So, dissolution and winding up. A lot of companies don't actually do this part, but I think it's useful. After you have sold, and for the purposes of this, we are presuming that the assets have been sold and not the business itself. If the business itself, the house from our original analogy, has been sold, then you don't have to dissolve it. It still exists, just someone else is living there. But a dissolution is where you basically say, I am done with this business. I no longer have any, the business is just it's a husk. There's nothing else going on. I don't want to pay taxes on it anymore. I don't want to incur any more liabilities on it. Let's just fold it. There are some basic parts to it, and I'll go over them really quickly because they're not all that interesting, and they're very state by state. But the dissolution is you give notices. You can either do publication notice of the dissolution, which I don't know if you've ever looked at your legal notices section of the newspaper. It is so interesting. I'm kidding, it's terrible. But you will see notices like, hey, we have started up a new entity, or this is, hey, we are shutting down our entity. If you think we owe you anything, here's how to give us notice of it. Here's how to tell us. You also file a certificate of dissolution or statement of dissolution with the Department of State. Hey, we're going out of business effective X date. At the same time, you file your final tax returns. You've already filed your bulk sale, right? Because we talked about that already. Sometimes you have to give notices to creditors as well, depending on the kind of dissolution you want to do. This can get a little tricky because creditors tend not to like to hear that you are going out of business, and they would like to get what they can when they can. So I have a dissolution going on right now. There is truly, I think my client that's winding up has, I think, $150 in the bank. They had to take the owner had to pay me for the fee to do this because there was no money left in the bank account for the business. And they have one creditor, and that creditor is loaded for bear. They want to be paid. And I keep saying, you were able to sell off some assets. That's amazing. Take your 16K and run with it. If you want $150 in the bank, take it because there's nothing else. But we had to give notice to those creditors because we wanted to close up the business really quickly. There's another way in the state where that was, Delaware, there's another way to do it, which takes 10 years. And you have to pay everyone in full. So we didn't want to do that. There was no money to pay anybody in full. So we did it the quick way. Anyway, once your creditors have told you what, if anything, they are owed, then you wind up the business and you see what kind of assets the business has, and you sell them, and you take the money and you pay off the debts. And if there's anything left over, it goes to the members or shareholders at the end of the day. And that's it. All right, I am ready for questions. Let's do some questions. All right, I'm going to go to the chat, take a look and see what there is.
All right.
All right.
You got it, Nella?
So,
And I think the ones that come in, just so you know, that we're not saying who they're from.
okay, that sounds great.
Thanks.
I'm going all the way down to, let's see.
Here,
Do you want me
I can field them for you, or Matt
Oh,
can.
that'd be great. Sure.
Yep.
Thank you.
Go ahead, Matt.
Sure. Does the bank make a one-time whole purchase amount payment to seller, or is it a payment plan?
They typically make a one-time purchase. It's a bulk. Like they just pay it. So if the business is, let's say, $300,000, they will cut a check for $300,000 less, whatever attorney's fees there are, or less the tax escrow that'll go into like a tax escrow account.
Thank you so much, Nella. That's the only one I see in the chat. There's a couple questions about the recording being made available. It will definitely be made available after the
hold on.
presentation. Oh, and we have a
Yeah, there's a couple more. So so if I have my business and I have 100 customers, can I sell off most of my client list and maybe keep 5 select, or is it all of our clients that we have to sell?
You can sell whatever you want. Now, I will say, if the 5 customers you have are your 5 best customers, then the price that you will be paying for the business will be less because, a buyer looking through your income and your customer list will say, oh, I see that over the last year, let's say you made $100,000 and 500 of it was, or $100,000, 50,000 was from these 5 customers. So if you're keeping those, then I'm going to pay you less. But you can do what you want. In fact, I usually like to have a list of what's not being sold in my asset purchase agreement, so it's really clear. Sometimes people want to keep customers, they want to keep certain elements of intellectual property. They want to keep what else they want? Oh, well, cash in the business, which you would think would not transfer, but some people are very adamant that that also should transfer.
Matt, you want to pop that last
Yeah,
question?
absolutely. We have a question. How are attorneys compensated?
Oh, that is a good question. It depends on what the deal is. So I personally have done both hourly on an ongoing basis, and I have done where I'm paid from the proceeds of the sale at closing. Both are fine and legitimate. My concern with getting paid out of the proceeds of sale is that the sale doesn't happen. So if the sale does not go through and I have incurred fees, how do I get paid? It's not a contingency. Like I'm not paid. It's I'm not paid based on the success of the sale. I'm paid because I do the work that goes into the process. So I think it really depends. I have been okay being paid out of the proceeds of sale, but I also have I want to make sure that if the sale doesn't go through, I will be paid anyway. But it's not usually a flat fee, and it's not contingency. I've never seen a sale close on a contingency basis ever.
Thank you
All
so
right.
much.
Yeah, I don't see any other questions. First off, Nella, thank you. That was an excellent presentation, very accessible. Like I've said, not lawyery, which I mean that in the best possible way, as anyone who's heard lawyers speak before. So again, thank you for our attendees that are here. Again, we've recorded this, so Matt's gonna work his magic. He's going to send this out in the next couple of days to you to review. It'll include Nella's contact information. If you can't wait, if you've got some hot burning questions and you didn't grab Nella's information, feel free to email us and we'll be happy to connect you with Nella. So with that, Nella, again, thank you very much.
Well, thank
Appreciate the
you.
time.
I appreciate the opportunity, and thank you so much to Sarah and to Matt, and also to everyone who attended. I know it was a bit dicey getting wherever you were going to go today, and it's gross out. So I appreciate you taking the time and braving the weather.
Good deal. All right, everyone. Thank you. Have a great day. Stay warm.